Wizera. We are joined by representation from the UPDF, Colonel Raphael Mugisha, Director of Prosecutions.
What do you mean representation from the UPDF?
My lords, these are our clients. Yeah.
You are representing them, so they are officials of the UPDF.
Yes, please. Much obliged. Director of Prosecutions, Joint Staff Legal Services, UPDF. Brother Major Edgar Musasizi, Director Civil Affairs, Joint Staff Legal Services, UPDF. And Lieutenant Achilles Boete, Staff Officer, Joint Staff Legal Services, UPDF. My lords, for the respondent, we have the Honorable Medad Lubega Segona, Mr. Kale Balaka, and Mr. Samuel Muyizi. And Mr. Abubakar Sekanjako. My lords, the respondent is in court. We are ready to receive the judgment.
I thought the Lord Mayor, who doubles as a lawyer, was representing one of the parties. Has he abandoned this client?
No, my lord, the firm has instructions. I hope I don't need the assistance rendered to the Solicitor General. My lord, the firm has instructions and I'm here.
You know, he has the habit of intruding into my turf when I don't need him. Now when I need him, he cowers.
My lord, you could use me whenever you need him. Thank you.
His visit was an invitation to treat. I'm now making an offer and he's not extending his hand. Thank you for everyone who has shown understanding in this matter. The judgment in this appeal will be delivered. Now, we will proceed by asking the other members of the panel deliver their judgments, and then the lead judgment will be read. And then I think we'll be happy to have you dismissed when we are done, so that we can go to do other things. So that those who have been very active can now become redundant. And they thought this judgment, like the return of Jesus, may not come, or no will come. Now it is here. The lead judgment is here, 200 pages. It will be read. So you prepare yourself for, I think it might take us 16 hours, but it will be read. So can I ask Lady Justice Monica Mugenyi to deliver her judgments?
Thank you, my Lord Chief Justice, and good morning, Council. This is my judgment. I have had the benefit of reading in draft the judgment of His Lordship, the Chief Justice, in this matter. I am in complete agreement with the position adopted therein in relation to ground 2 of this appeal. I do also abide the position under ground 1 that the General Court Martial established under Section 195 of the UPDF Act is a subordinate court of competent jurisdiction under Article 129(1)(d) of the Constitution. I would, however, respectfully adopt a slightly different approach to the scope of service offences under the UPDF Act. I therefore consider it necessary to provide my perspective to that issue within the context of the entire appeal. The elements of a right to a fair hearing, as highlighted in Article 28(1) of the Ugandan Constitution, are similarly expressed in various international covenants, the pertinent one for present purposes being the International Covenant on Civil and Political Rights. The United Nations Human Rights Committee the United Nations Human Rights Committee
Can you please check on, is there some sabotage? Please work on the gadget where people want to hear what Lady Justice Monica is saying, as they want to hear what each one of us will be saying.
Hello? It's not working. It's not on. Can it be heard now?
The end there. Mr. Franklin Ubizera, State Attorney. Franklin. The end there. Mr. Franklin.
Yes, hello. Hello? Is that maybe increase the volume a little?
Hello?
Increase the volume.
Hello? Testing. Much better. Hello? Hello?
Hello, yes, I think we are set now.
hello, hello. You know the problem you have to. Hello, hello, hello. No, I tested. Hello, hello, hello. Testing, testing, testing. Hello, hello, testing, testing. Hello. No, hello. My Lord, this matter is coming up for judgment. Constitutional Appeal number 2 of 2021, the Attorney General versus the Honorable Michael Kawasguruka. Quorum.
No, just say the court is constituted as before.
Much obliged, my Lord. The court is constituted as before, my Lord.
Thank you. Please, you can continue.
Thank you, my Lord Chief Justice. The elements of the right to a fair hearing, as highlighted in Article 28(1) of the Ugandan Constitution, are similarly expressed in various international covenants, the pertinent one for present purposes being the International Covenant on Civil and Political Rights. The United Nations Human Rights Committee has since pronounced itself on Article 14 of the ICCPR in its General Comment number 13 of 1984 and General Comment number 32 of 2007. General Comment number 13 proposes that the trial of civilians in military courts should ensue in very exceptional circumstances and in conditions that genuinely abide the dictates of Article 14 of the ICCPR. It was in January 2006 supplemented with the draft principles governing the administration of justice through military tribunals. The draft principles on military tribunals were rooted in the 1984 General Comment number 13 and must now be construed with due regard for the committee's revised position as encapsulated in the 2007 General Comment number 32. General Comment number 32 demonstrates that the Human Rights Committee does recognize the trial of civilians in military courts, albeit in exceptional circumstances and within established parameters. It calls upon state parties to guarantee the fairness, impartiality, and independence of such trials, which in any event would only be justified in exceptional circumstances and for serious and objective reasons, with appropriate regard for the suitability of civilian courts for the individuals and offenses in question. That is the universally established command of Article 14 of the ICCPR. Courts martial are established by the UPDF Act by dint of Article 210 of the Constitution to preside over the service offenses defined in Section 1 of the UPDF Act, which include the offenses enshrined in Part 6 of that Act. The intricate nature of the service offenses they preside over supports the view that the primary function of courts martial is indeed to foster the efficacy of the military in securing the country and its borders. The enforcement of discipline within its rank and file is a vital component of that objective, but is certainly not the sole function thereof. Be that as it may, the main bone of contention as far as the jurisdiction of the General Court-Martial is concerned appears to be the status of that military court in the national judicial system. Black's Law Dictionary defines a competent court, which is interchangeably referred to as a court of competent jurisdiction, as I quote, a court that has power and authority to do a particular act, one recognized by law as possessing the right to adjudicate a controversy, close quote. In the matter before the court presently, the juridical competence of courts martial can be deduced from the definition of a court in Article 257(1)(d) of the Constitution as juxtaposed against Articles 123(b), 137(5), and 257(2)(a)(1) of the Constitution. I find fortitude for this view in the case of Attorney General versus Joseph Tumshave, where this court adjourned the General Court-Martial to be a subordinate court. I therefore abide the position in the lead judgment that the General Court-Martial is a subordinate court of judicature within the confines of Article 129(1)(d) of the Constitution. However, the respondent extends his displeasure to the legislature, faulting it for supposedly exceeding its legislative powers when it created the General Court-Martial under the UPDF Act and conferred it with criminal jurisdiction over non-military persons and civil offenses. Parliament has a broad legislative mandate under Article 79(1) of the 1 and 3 of the Constitution to enact laws in the interest of national peace, order, and good governance. Article 210(a) and (b) further empowers Parliament to enact laws that govern the UPDF's organs and structures, as well as its discipline. Having found that the General Court-Martial is indeed a subordinate court of judicature, it follows that its establishment under the UPDF Act and the delineation of its jurisdiction therein was well within the remit of Parliament. However, the scope of that jurisdiction is a matter of contention before this court. I find that the term service offense in Section 1 of the UPDF Act would encompass the offenses created under Part 6 of the UPDF Act in relation to the persons delineated under Section 1171A to F of that Act, as well as offenses under any other act that are committed by the same category of persons. Hence, the scope of service offenses in question restricts the inclusion of civil offenses to those cases where the civil offenses are committed by persons that are in active military service as delineated under Section 1171A to F of the Act, and on field operations. Persons that are not in active military service but only became subject to military law by dint of subsection 1171G and H of the Act would not be tried for service offenses in the military courts. I now turn to the contentious question of the jurisdictional scope of the General Court-Martial over civil offenses. I do acknowledge the position taken in Attorney General versus Joseph Tumshabe that there is no provision of the Constitution that restricts Parliament from vesting a subordinate court with jurisdiction that is also within the purview of the High Court. For present purposes, however, I take the view that this lacuna should be interrogated with regard to the special character of courts martial and existing international safeguards in respect of military courts. Principle 8 of the Draft Principles of Military Tribunals considers crimes committed in the course of field operations to be sufficient justification for the trial of civil offenses by military courts. Indeed, Section 198(2) of the UPDF Act does recognize the function of field courts martial in presiding over offenses committed in the course of field operations, I quote, where it is impracticable for the offender to be tried by a unit disciplinary committee or a division court-martial, close quotes. This position is reiterated in Section 177 of the Act, albeit with additional emphasis on a civil offense translating into a service offense, whether committed within or outside Uganda. I am alive to the character of courts martial as special courts that are set up to address a specific area of the law, having a more limited jurisdiction than the courts of general jurisdiction, being faster and often not bound to follow the same procedural imperatives, and field court martials are particularly characterized by quick processes that are not unduly bogged down by the procedural imperatives that obtain in general jurisdiction civil courts or indeed other courts martial, given the peculiar conditions within which they operate. Indeed, the Constitution recognizes the peculiarity of fields court-martial when in Article 137(5), it exempts their processes from constitutional references. In those circumstances, closing such field courts-martial with jurisdiction over capital offenses that attract a potential death sentence might appear gravely ill-advised, but for the following two critical conditions. First, to restrict field courts-martials to non-capital civil offenses would be to leave capital offenses that are committed in those sometimes fluid situations uncatered for and unaddressed. This indisputably would be inimical to the administration of criminal justice and an affront to the rule of law, which subjects all persons to the law. Secondly, Principle 17 of the Draft Principles on Military Tribunals is emphatic on the right of appeal from courts-martial, which by extension would include field courts-martial. Accordingly, the right of appeal from the decision of a field court-martial does provide a vital safeguard to the exigencies of their judicial processes. Its relegation to creation by subsidiary legislation is a misnomer that ought to be revisited. In the event, I would abide the proposition in Principle 8 of the Draft Principles on Military Tribunals that the circumstances under which field courts-martial operate do provide sufficient justification for their jurisdiction to try civil offenses, including capital offenses. Having so held, and considering that the General Court-Martial sits in appeal over decisions of field courts-martial, I would refrain from excluding civil capital offenses from its jurisdiction. I now turn to the constitutionality of Section 1171G and H of the UPDF Act. The controversy as to the constitutionality of those statutory provisions has arisen in numerous cases with varying results. It now falls to this court, under the present appeal, to pronounce itself with finality on the matter. The fundamental question is whether the parameters that are encapsulated in Section 117(1)G and H amount to exceptional circumstances that would justify the trial of civilians in military courts. The law is a major component of public policy and would thus be vital public policy consideration for the justification of the trial of civilians in military courts. Indeed, I am alive to the duty placed upon Ugandan citizens under Objective 29 and Article 3.4 of the Constitution to uphold and defend the Constitution and the law. This perhaps explains why criminal law considers a person that aids or abets the commission of a crime or has a common intention with others in the commission of a crime is criminally culpable. Reading Section 1171G of the UPDF Act, together with Section 191C of the Penal Code Act, would suggest that a person that aids or abets a serving or active military person in the commission of the service offences delineated in Part 6 of the Act would be deemed to have taken part in committing the offence, be guilty of the offence if proved, and may be charged with actually committing it. In practical terms, Ayume Francis in Criminal Procedure and Law in Uganda posits that a person who aids and abets another in the commission of a crime may be joined in one charge sheet and tried together with those who actually commit the crime, but the particulars of the offence must clearly indicate the role of the aider and abetter. I take the view, therefore, that criminal culpability by way of aiding and abetting the commission of a service offence is sufficient justification for the subjection of a civilian to military law. I respectfully do not abide the view that such trials should not axiomatically ensue in the civilian courts. In my view, the fact that the principal offender is a person in active military service and charged with a purely service offence warrants the recourse to military courts as opposed to civil courts for the trial of both the principal offenders and their accomplices. Furthermore, the intricate nature of service offences encapsulated in Part 6 of the UPDF Act would be better suited for trial before military courts rather than civil courts. I would, however, abide the exemption posited in Oxford Dictionary of Law that, and I quote, when a member of the armed forces is charged with conduct committed that is an offence under both service law and the ordinary criminal law, the trial must, in certain serious cases, e.g. treason, murder, manslaughter, and rape, be held by the ordinary criminal courts and is in fact usually held by them in other cases, close quotes. I would construe this position to draw a distinction between the pure commission by a military person of a service offence on the one hand and a service offence that is also available as a civil offence. In addition, though seemingly restricted to capital offences, I would extend it to non-capital offences that accrue as both service offences and civil offences. In my view, therefore, the general rule ought to be that military service offences are only triable in military courts and civil offences are only triable in civil courts, save for two exceptions: the trial by field courts-martial of military persons that commit civil offences during field operations, and the trial of service offences by civil courts, where such offences do also exist on the ordinary criminal law statute books. I would therefore uphold the majority in the Constitutional Court that civilians that aid and abet military persons in the commission of a service offence do by their actions subject themselves to military law under Section 117(1)G of the Act. Section 1171H, on the other hand, subjects to military law any person found in unlawful possession of arms, ammunition, equipment, ordinarily being the monopoly of the defence forces or other classified stores. I find no definition in the Act as would guide a reasonable member of the public as to what type of military equipment is the monopoly of the UPDF, let alone what would amount to classified stores so as to avoid the prohibited conduct. Article 2812 of the Constitution considers a criminal offence that is not adequately defined to undermine the right to a fair trial and thus prohibits convictions arising from vague and ambiguous criminal offences. The need for a precise definition of an offence is associated with the principle of legality that translates into the constitutional principle of void for vagueness. The void for vagueness doctrine essentially requires that a penal statute define the criminal offence with sufficient definiteness that ordinary people can understand what conduct is prohibited and in a manner that does not encourage arbitrary and discriminatory enforcement. Thus, legislative provisions that have not been defined with sufficient conciseness have invariably been adjudged to be void on account of their vagueness. On that premise, therefore, I am unable to endorse the constitutionality of Section 117(1)(h) of the Constitution. In the result, I find that service offences as defined in Section 1, as well as the provisions of Section 177 of the UPDF Act, are not at cross purposes with either the legislative mandate of Parliament or the objective of the UPDF under Article 210A of the Constitution. Nor in any case are they inconsistent with Articles 28(1) and 44C of the Constitution. I do additionally find that the provisions of Section 117(1)(g) of the UPDF Act do constitute exceptional circumstances under which the subjection of civilian offenders to military courts would be justified. To that extent, that statutory provision is not inconsistent with the Constitution. I, however, find Section 117(1)(h) of the Act to be void for vagueness and therefore inconsistent with Article 28(12) of the Constitution. I would accordingly resolve ground 1 of the appeal in the affirmative, but respectfully find no merit in either ground 4 of the appeal or the cross appeal. I now turn to grounds 2 and 3 of the appeal. The right to a fair trial is anchored in the principle of judicial independence, which in the Ugandan Constitution is articulated in Article 128. In the same vein, Principle 13 of the Draft Principles on Military Tribunals proposes, I quote, "The organization and operation of military courts should fully ensure the right of everyone to a competent, independent, and impartial tribunal at every stage of legal proceedings. The persons selected to perform the functions of judges in military courts must display integrity and competence and show proof of the necessary legal training and qualifications, and military judges should have a status guaranteeing their independence and impartiality, in particular vis-a-vis the military hierarchy." Close quote. The UN Human Rights Committee additionally enjoins states to take all necessary measures to ensure that such trials take place under conditions which genuinely afford the full guarantees as stipulated in Article 14. The African Commission of Human and People's Rights has similarly adopted the stance that military tribunals must be subject to the same requirements of fairness, openness, and justice, independence, and due process as any other process. Thus, in the Constitutional Rights Project versus Nigeria, it decided that a tribunal comprised of one judge and members of the armed forces could not be considered impartial because regardless of the character of the individual members of such tribunals, its composition alone creates the appearance, if not of impartiality and bias, close quotes. The General Court Martial of Uganda was established under Section 195 of the UPDF Act. It is composed of 7 members, all of whom are appointed by the High Command for a period of 1 year, subject to reappointment by the same appointing authority. Its membership is solely comprised of military persons, with no provision whatsoever for their professional qualifications. Neither are such qualifications provided for its reserve members. Therefore, although at any one time the actual members of the General Court Martial could very well possess the requisite qualifications, its de jure composition is purely restricted to qualification on the basis of military service. In Inkawa versus Turkey, the European Court on Human Rights, the European Court on Human Rights highlighted the specific factors that would be taken into account in determining the impartiality and independence of military judges. The court astutely identified the crux of the matter as the confidence which courts in a democratic society must inspire in the public, and above all, as far as criminal proceedings are concerned, in the accused. It further deduced the parameters that will support the independence and impartiality of military judges to include the same professional training as civilian judges and the enjoyment of constitutional safeguards identical to those applicable to civilian judges. It additionally expresses concern about military judges being servicemen who still belong to the army, which in turn takes its orders from the executive. And they remain subject to military discipline, and the appointment of these officers is made by army structures for a short renewable term. That decision is most persuasive on the standard of independence and impartiality expected of military judges on military courts. In any event, the concerns expressed in it are re-echoed in Principle 13 of the Draft Principles on Military Tribunals. Paragraph 7 of that draft principle emphasizes equivalence in professional qualifications, ethical standards, and constitutional safeguards between judges in civilian courts and their counterparts in military courts as a safeguard for their independence and impartiality. In the matter before us, the respondent, having pointed to the impugned Section 195 as the legal basis for his misgivings with his trial before the General Court-Martial, the evidential burden shifted to the appellant to factually demonstrate the independence and impartiality of that court. Regrettably, such evidence was not forthcoming. I do not accept the appellant's proposition that military courts in Uganda are impartial and independent simply because Article 221 of the Constitution enjoins the UPDF to observe and respect human rights in the performance of its functions. In my view, that constitutional imperative is simply a directional standard for courts martial rather than a factual situation that pertains to them. Consequently, in complete agreement with the lead judgment, I find that the Constitution of the General Court-Martial does compromise its independence and impartiality as a subordinate court of unlimited jurisdiction and is to that extent inconsistent with Article 28(1) and 44(c) of the Constitution. In the result, I would resolve ground 2 of this appeal in the negative. On the other hand, under ground 3 of the appeal, the respondent's arraignment before the General Court-Martial is specifically challenged on account of the omission in the charge sheet to indicate his role in aiding and abetting the commission of a service offense as contemplated under Section 117(1)(g) of the UPDF Act. As was earlier observed herein, a person that aids or abets another in the commission of an offense is deemed to have taken part in the commission of the offense and, if proved, would be guilty of that offense. In the instant case, an incomplete charge sheet was annexed to the affidavit in support of the petition as Annexure A. It reveals that A1 to A8, with whom the respondent was arraigned, were at the time in active military service and therefore automatically subject to military law. The respondent, on the other hand, is depicted as a civilian, a member of the 10th Parliament of the Republic of Uganda, representing Nakawa Division in Kampala District, and designated as a person subject to military law by virtue of Section 119(1)(g), 117(1)(g) of the UPDF Act. Under count 1 of the charge sheet, the statement of offense is stated as offenses relating to security, contrary to Sections 131F of the UPDF Act, while the particulars of offense indicates that the respondent, together with 22 other named persons and others still at large, between the months of February and June 2016, in diverse places in Wakiso, Kampala, and Luwero districts, with intent to prejudice the security of the defense forces, contrived a plot to overthrow the government of Uganda by force of arms. Close quotes. Although the charge sheet referred to in Section 117, I'll say that again. Although the charge sheet referred to Section 117(1)(g) of the UPDF Act under the description of the respondent, it did not spell out his role in the commission of the alleged service offense. This would indeed amount to a defect. However, not every defect in a charge sheet would make it bad in law and render the ensuing proceedings a nullity. The test to be applied is what the effect of the defect is and whether, if proceedings are concluded, it has occasioned a miscarriage of justice. In this case, no attempt was made to demonstrate any such miscarriage of justice. On the contrary, insofar as the charge sheet highlights the statutory provision that brings the respondent under military law, which is clear on the issue of aiding and abetting the commission of a service offense, the respondent would have been on notice of the nature of offense he was arraigned for. Furthermore, the charge sheet spells out the principal offenders by highlighting their status as persons in active military service. Moreover, borrowing from the civilian courts, under Section 132 of the Magistrates' Courts Act, a court that is faced with a defective charge has a wide discretion to amend it at any stage of a trial. As a similarly subordinate court, that option of amendment of the charge would have been available to the General Court Martial to clarify the specific role played by the respondent in the alleged offense, as well as demarcate who of the persons he was arraigned with were the principal offenders. Consequently, given the procedural reliefs available to him, I do not find the defects in the charge sheet in this case to constitute sufficient reason to declare the respondent's arraignment before the General Court Martial a violation of the right to a fair trial. However, given the then de jure composition of the General Court Martial under Section 195 of the UPDF Act, the respondent's arraignment before that military court cannot have been in accordance with the right to a fair trial before an independent, impartial, and fair court, as envisaged in Article 28(1) of the Constitution. I would accordingly resolve ground 3 of the appeal in the negative. This brings me to what would be appropriate remedies in the circumstances of this case, and whether or not they should apply retroactively. Black's Law Dictionary distinguishes true retroactivity from quasi-retroactivity, the former consisting of the application of a new rule to matters that were completed before the rule came into force, and the latter entailing the restriction of a new legal rule to matters pending completion. In Griffith versus Kentucky, the U.S. Supreme Court reiterated its view in United States versus Johnson on the need to apply a new constitutional rule to all criminal cases pending determination in order to uphold basic norms of constitutional adjudication. That case was cited with approval by the Constitutional Court in Mabea versus Attorney General, and I still consider it to be good law. I would thus equally cite with approval the observation in Duke Mabea versus Attorney General that a new constitutional rule in the realm of criminal procedure be applied quasi-retroactively or restricted to cases pending final disposal to avert the dire effect on the rule of law and the administration of justice of full retroactivity. Griffith versus Kentucky additionally posits that unlike the legislature, it is not the function of the judiciary to formulate laws on a broad basis, its role being limited to the declaration of a new rule directly arising from adjudication. This is similarly acknowledged by the Canadian Supreme Court in the case of Skakta versus Canada. That case was relied upon in Fish Eric in the article Choosing Constitutional Remedies by Fish Erickson. The choice of appropriate remedy between severance and reading in, where a statutory provision violates the Constitution, hinges on whether the nature of the constitutional inconsistency entails something improperly included or excluded from the statute. In the matter before us presently, Section 195 excludes such professional competencies in the membership of the General Court Martial as would mitigate connotations of partiality and non-independence. As such, reading those omissions into that provision might have been the more appropriate remedy, but for the fact that the deference to the competence of persons with a military background was at the time informed by the scarcity of legal professionals in the military, as well as the complexities of securing legal professionals for field courts martials. This is borne out by the parliamentary debate in respect of the then Uganda People's Defense Forces Bill, as reported in the Hansard of that time. So that reading into Section 195 of the UPDF Act, the constitutional safeguards and membership as the court deems appropriate would be tantamount to the usurpation of Parliament's legislative function by judicial overreach. However, the same SACTA case proposes another constitutional remedy that gives the legislature a chance to craft its own solution. Provision for legislative reform therein would, in my view, address the shortfalls of the previous legislative process and provide an opportunity for the review of the military justice law in Uganda, as has been done in other jurisdictions. This would align it with the independence and impartiality safeguards envisaged in the right to a fair trial under the Constitution. It will suffice to observe here that unlike judiciary-driven reforms that ought to be restricted to matters that were in contention between the parties, legislative reform may holistically address matters that were not necessarily in issue before this court. It might similarly accrue to the right to a fair trial in courts martials. This would forestall avoidable litigation in respect of related matters and abide the notion of judicial economy. Disposition. The upshot of my judgment is that this appeal partially succeeds while the cross appeal fails. I do abide declarations 1, 2, 3, and 6, orders 3 and 7, as well as the advisory orders D, E, and H as stated in the lead judgment. In the result, I would set aside the judgment and orders of the Constitutional Court and substitute them with the following declarations. 1. The General Court-Martial is a subordinate court of competent jurisdiction within the confines of Articles 129(1)(d) and 257(1)(d) of the Constitution, but its de jure membership under Section 195 of the UPDF Act does undermine its independence and impartiality and is to that extent inconsistent with the fundamental right to a fair trial enshrined in Article 28(1) and 44(c) of the Constitution. 2. The respondent's arraignment before a general court-martial, the de jure membership of which does not pass constitutional muster, was a violation of his right to a fair trial and to that extent is inconsistent with Article 28(1) and 44(c) of the Constitution. 3. The provisions of Section 117(1)(g) of the UPDF Act do delineate exceptional circumstances that would justify the trial of civilians in military courts and is to that extent consistent with the right to a fair trial as enshrined in Articles 28(1) and 44(c) of the Constitution. 4. Section 117(1)(h) of the UPDF Act is void for vagueness and therefore inconsistent with the right to a fair trial as enshrined in Article 28(12) of the Constitution. 5. Service offenses as defined in Section 1, as well as the provisions of Section 177 of the UPDF Act, are not at cross purposes with either the objective of the UPDF Act under Article 210 or the legislative mandate of Parliament under Articles 79, 129(3) and 210 of the Constitution, nor in any case are they inconsistent with Articles 28(1) and 44(c) of the Constitution. I shall pronounce my final order as the quasi-retrospective application of all cases pending before the General Court-Martial in light with Order 2 above. I would respectfully propose the following additional advisory order for consideration. The General Court-Martial be substantially composed of civilian judges who are directly appointed thereto by the Judicial Service Commission in accordance with the Constitution, as is presently done in respect of judges of the Industrial Court, and the members of the General Court-Martial from within the military should be appointed in consultation with the Judicial Service Commission. I would so order.
Councillor Alaka, during my time, you would have the decency of bowing to a judge who...
Chief Justice, we are about to stand because we are so much obliged, my lord.
Thank you. Can we have Lady Justice Catherine Babugemerere deliver her judgment?
Thank you, my Lord Chief Justice. I have had the opportunity to read the draft opinion of the Honorable the Chief Justice. He ably sets out the questions for determination before us and has cited the relevant sections of the UPDF Act, Cap 330, and the related constitutional provisions which are said to have been contravened. Please note that the sections of the law I will be quoting are quoted from the immediate past laws of Uganda volumes and also from the most recently published edition. So in my final judgment, you will find two versions of laws. When I read them, I'll read the one that was probably cited during the hearing. I would allow this appeal in part. The Attorney General lodged an appeal against the decision of the Constitutional Court dated 1st July 2021. The respondent had challenged the competence of the General Court-Martial to try civilians under the Uganda People's Defence Forces Act, alleging that the continuance of these trials violates constitutional provisions, including Articles 28(1), 44C, and 210 of the Constitution of the Republic of Uganda. The Constitutional Court, being the court of first instance in constitutional matters, heard the petition and decided that the General Court-Martial is a constitutionally established court set up to handle cases of military discipline for the UPDF members, but lacks jurisdiction to try civilians for offenses under the Penal Code or other enactments. As a result, Sections 2, which now reads as Section 1, Sections 1191H, and Section 179 of the UPDF Act, which expand military jurisdiction of the courts martial to include civilians and classifies civil offenses as service offenses, were declared unconstitutional for violating fair trial guarantees and exceeding the mandate under Article 210B of the Constitution. Finally, the court found that Section 119 is not unconstitutional, provided the person not otherwise subject to military law is tried as an accomplice together with a person who is subject to military law as the principal offender on the same charge sheet. I am abundantly aware of the tension that exists between ensuring unfettered military discipline and compliance with the tenets of constitutional right to a fair trial, which should be available to all human beings, including men and women who serve in the military. This entails a delicate balance on a constitutional landscape which the courts are obligated to navigate. I have, in my judgment, undertaken a synopsis of the historical evolution of courts martial in order to locate their relevance and effect in our current systems. In this regard, I have considered the era of the Romans. While the Roman Empire is often considered one of the most influential and impactful empires in history, most historians would not consider it to have been the greatest empire in terms of sheer size. However, the Romans are credited with codifying and maintaining accurate records. The Roman Empire's legacy of military discipline is notable for its extreme punishments, such as dissemination, where 1 in 10 soldiers were executed for collective disobedience. Collective disobedience included such offenses as mutiny, and mutiny included offenses like tree-sitting, sabotage, among others. Tree-sitting meant that the rank and file of men in the mutiny would choose to sit under a tree and not do any work. Annihilation was the extreme measure historically used to enforce discipline in the rank and file of the Roman army. In the latter years, the Normans emerged following the Romans. The Normans, or the Normandy, introduced trial by combat to settle disagreements over money or chattels, movable or immovable, including land. Participants engaged in physical combat until one was killed or too wounded to continue. The loser was hanged, reflecting the belief that God had found them guilty. This particular practice of combat was outlawed in the 19th century, with survivors being charged and tried for criminal offenses. One of the Normandy kings, William the Conqueror, developed military justice and influenced feudal traditions in the United Kingdom, including duels, and again, trial by combat. The duel significantly influenced modern culture. The duel was, just like the combat, a situation where two persons who had a conflict fought it out physically. The duel in our modern days is the equivalent of the adversarial system in the court, where lawyers for and against parties do battle. The lawyer's sword today in court is his spoken word. It is a duel of words, but it was a duel in the Norman days. The shire courts were introduced by William the Conqueror and maintained by him. These were courts made up of clergy and local leaders who sat and decided cases and received alms from their salaries. That also explains the lawyers' dressing today. It came from the shire courts. Under William the Conqueror, the principle of resolving disputes within the military hierarchy persisted and influenced courts martial. We'll then go to King Gustavus Adolphus. King Gustavus Adolphus of Sweden formalized military justice with his 167 articles of war, introducing regimental and standing courts martial to enforce discipline and morality. These systems were credited with fairness and morality, and hence influenced both Europe and the British military laws. And up to date, there are military academy known as the Gustavus Academy. The Soviet Union. The Soviet Union discipline of its rank and file was enforced through punishments, awards, incentives, and enhanced patriotic zeal. Severe discipline was demanded by Lenin and Stalin to effectively use modern war implements like tanks and airplanes. The punishments in the Soviet Union included drinking restrictions, surveillance, counter-surveillance, and even physical searches. One of the most notorious infractions a Soviet soldier could commit was drunkenness. The persistent inspection and searches of the soldier military personnel frequently made it difficult to smuggle alcohol into their garrisons and posts. A non-fiction writer identified alcohol as the primary cause of disciplinary infractions in the Soviet armed forces, resulting not only in drunkenness, but also in theft, bribery, record falsification, and deliberate damage. Alcohol was used not only to deaden the senses and allow a period of escape from the hardships and pressures of daily life, but was also used to celebrate and commemorate every event. Soviet soldiers and sailors were supposedly only permitted to drink when expressly allowed in accordance with the regulations. The Soviet soldier drank when the opportunity to drink presented itself, in direct violation of disciplinary restrictions. They were so starved of drinking that they resorted to drinking the eau de cologne, eating shoe polish when vodka was unavailable. This infraction, though minor, could lead to severe punishment, including imprisonment or banishment to Siberia. The British military system, originating from the medieval court of the chivalry, involved tribunals. The decline of the court of chivalry led to councils of war, which addressed offenses such as mutiny and desertion. They enacted the Mutiny Act of 1789, which established a legal framework for the courts martial, ensuring discipline while introducing procedural safeguards. Key issues included the struggle for control over the military justice system and the development of military due processes. The American military justice system originated during the Revolutionary War, drawing heavily from the British military codes. Post-World War II dissatisfaction with the wartime military justice led many Western countries to adopt more judicial approaches and procedures in their military justice. The American military justice has often seen the intervention of the US Supreme Court in military matters. The question of the status of the offender are constantly under review. A status of the offender determination by the courts helps in restricting which offender is liable to appear and be tried before a court-martial. Often, the spouse or dependent of a serving officer and a civilian worker connected to the military either lose or have their day in court when found offending. The cases of Milligan, O'Callaghan, Kinsella, and Curry are but a few examples of judicial review of military justice. The determination of what amounts to peacetime and wartime offenses are interrogated by the civilian courts. Uganda's military justice system. Uganda's military justice system was influenced by the British military law, partly because we were colonized by that country. Fast forward, the 1975 Economic Crimes Tribunal, established by the government of the day between 1971 and 79, was established to punish profiteers, hoarders, and others acting against the state's economic interests, with penalties including death by firing squad or imprisonment. During the period 1971 to 1979, military tribunals often tried civilians and soldiers alike with little regard for fairness or due process. The system was highly politicized, with military tribunals taking precedence over the civil courts. In its military institutional framework, Uganda borrows heavily from the British, the American, and indeed the Soviet or former Soviet states militaries. We have offices such as the judge advocate and the political commissar, which are vestiges of our non-aligned associations with those countries. I will now move to the matters at hand. Notably, the provisions in Section 119 are at odds with the constitutional guarantees under Chapter 4 and 8 of the Constitution of the Republic of Uganda. The current status of courts-martial in Uganda is that all officers who sit on the General Court-Martial are serving army officers who are appointed by the High Command and are men under authority at all times. This means that the setup of the military courts does not follow a process that gives assurances that they will be independent and will deliver justice without fear or favor. By the very nature of their appointment, the structure and the reporting lines, courts-martial are firmly under the superior command and possible instruction of their bosses. Articles 21 and 28 of the Constitution, which provide for equality before the law and a fair trial, offers the following guarantees. The guarantee for equality. Equality means that all persons who appear before a tribunal or court of law are treated equally regardless of their race, their gender, age, or other factors. Presumption of innocence. That an accused is presumed innocent until proven guilty. Burden of proof. That the prosecution must prove its case beyond reasonable doubt. An independent and impartial tribunal. The trial must be conducted by an independent and impartial tribunal. Opportunity to present evidence. The accused is granted the opportunity to present evidence and to challenge the prosecution's evidence through cross-examination. Right to an interpreter. That the accused has a right to an interpreter if they cannot understand the language being used in court. Protection from self-incrimination. That the accused has protection from being forced to incriminate themselves. Right to a public hearing. That the trial shall be open to the public. Right to be represented by a lawyer. That the accused has the right to be represented by a lawyer of her choice at all stages of the trial. I have found that the determination of the jurisdiction of the courts-martial attracts investigation of the legislative intent of creating it. And I ask the question, was it the intention of Parliament to vest the courts-martial with jurisdiction to try only serving officers for committing a service offense, or was it their intention to extend military jurisdiction to civilians? Reverting to the long title of the UPDF Act, it is clear that the application of the law was intended to be restrictive rather than general, as it specifically states that it is an act to regulate the Uganda People's Defense Forces. To this end, Section 197 of the UPDF Act also states clearly that there shall be a courts-martial for defense forces. How does this stand with the Constitution? Article 44 of the Constitution provides 4 non-derogable rights. The safeguards given under Article 44 include protection from torture, cruel, inhuman, or degrading treatment or punishment. The second is a protection from slavery and servitude. The third is a right to a fair hearing. And finally, an entitlement to a writ of habeas corpus. Essentially, these 4 rights are established as non-derogable, meaning they cannot be taken away even in emergency situations. When juxtaposed against constitutional provisions, Sections 1191 G and H and Section 179 of the UPDF Act are found to be in contravention with Articles 28, 43, and 44 of the Constitution of the Republic of Uganda. The jurisdiction of the courts-martial is properly vested where there is a demonstrable connection and causal link between the service offense alleged to have been committed and the status of the offender as an active duty and image bearer of the armed forces. The status of the accused is pertinent in establishing the jurisdiction of military courts over civilians. It cannot be overstated that courts-martial present a viable means of implementing military justice in a practical, efficient, and flexible manner. We would borrow from other jurisdictions which make a proposition that national defense mandates an armed force whose discipline and readiness are not unnecessarily undermined by the often deliberately cumbersome concepts of civilian jurisprudence. Yet the dictates of individual liberty clearly require a check on military authority in the conduct of courts-martial. The provisions of the American Unified Code of Military Justice with respect to court-martial proceedings represent a congressional attempt to accommodate the interests of justice on the one hand, with the demands for an efficient and well-disciplined military on the other hand. Indeed, the true test to be directed toward comparing courts-martial with contemporary civilian forums is not that we have improved from an epoch that was said to be unjust, but rather that we are comparing favorably with the current constitutional mandate. So when I talk about the historical evolution of the military justice, the idea is not to say that since things got better, but rather to say where do we stand today? The true test ought not to be that military justice today has a semblance of due process. Rather, the test should be whether the military court-martial as it currently is living up to and can be held against the standards that offer protections for individuals against prosecution, detention, without trial, and do not permit any limitation of enjoyment of rights and freedoms beyond what is acceptable or demonstrably justifiable in a free and democratic society. I find that it is constitutional to create and have general court-martials. Historically, the purpose of the general court-martial was to instill and maintain discipline in the rank and file of the armed forces. To the extent that it exists to discipline and bring justice to its own rank and file, who are in conflict with its laws, its processes, and its procedures, the existence of the court-martial cannot be questioned. Let me conclude on this note. Courts-martial are specialized disciplinary tribunals with restrictive functions to handle disciplinary matters that are peculiar to and connected with the discipline and regulation of the armed forces. The Constituent Assembly, while debating the setup of the Army courts back in 1992, envisaged military courts as special purpose vehicles to enforce discipline within the military and ensure that there was a battle-ready and disciplined force anytime they were needed. Leading up to the enactment of the 1995 Constitution, the CA did not support granting army jurisdiction over civilians. The Constituent Assembly laid emphasis on the necessity to guarantee a free and fair trial and other due process rights and critical need for the independence of the courts-martial, stressing that their role be limited to handling military-specific offenses against military personnel. The General Court-Martial, as currently set up under the UPDF Act, is fundamentally incompatible with the constitutional safeguards for a fair hearing and is unconstitutional, and therefore its exercise of judicial power is equally unconstitutional. To re-echo the words in Curry, the court-martial system structure, including the convening authority's power to prefer charges and select court-martial members and report back to superiors, is fundamentally at odds with the due process and constitutional in the civilian justice system, and even unjustified in the military justice system. Having found as above, I hereby make the following declarations. Judicial power in Uganda is exercised by the courts of judicature, and such subordinate courts as Parliament may by law establish. The court-martial system established under Section 197 of the UPDF Act is therefore one such subordinate court. I would declare that Section 197 of the UPDF Act, which establishes the General Court-Martial, is not in breach of the Constitution. However, it is an overreach when the UPDF Act creates an offense that targets persons not otherwise subject to military law, making them criminally liable before the court-martials for offenses of aiding and abetting. For creating such vulnerability, I would declare Section 117, which it is now, and Section 1171H, 1177 of the UPDA Act unconstitutional. I would set aside the decision of the Constitutional Court in this regard. I find Sections 1, Section 177, and Sections 1171G of the UPDA Act in its current form unconstitutional for enabling the surreptitious prosecution of civilians in military courts. For clarity, the above sections provide that every person found in unlawful possession of arms, ammunition, equipment ordinarily being the monopoly of the defense forces or to other classified stores as prescribed is liable to be prosecuted before a court-martial. I uphold the decision of the Constitutional Court to the effect that the General Court-Martial is a constitutionally established court set up to handle cases of military discipline for UPDF members, but lacks jurisdiction to try civilians for offenses under the Penal Code or other enactments. I would declare that the arrest, detention, prosecution before the courts-martial of the cross-appellant stroke respondent and civilians of equivalence under Section 1191G, read 1171G, is in breach of Articles 21, 28, and 44 of the Constitution of the Republic of Uganda. For reasons above, I would make the following orders. In their current form, courts-martial are not in a position to deliver a free and fair trial as guaranteed under Article 28(1) and 44 of the Constitution of the Republic of Uganda. I would forthwith suspend all operations of courts-martial save for the hearing of disciplinary matters pertaining to serving officers. All convictions and sentences passed by courts-martial would be suspended. A pathway would be put in place to ensure that all citizens hitherto convicted and sentenced by the military courts-martial have their convictions and sentences subjected to judicial review before a civilian court of competent jurisdiction to determine whether the convict received a fair hearing and impartial prosecution. This order would not apply to persons who were convicted and sentenced by courts-martial and have already served their sentences. For efficiency and proportionality purposes, I would invoke the doctrine of prospective annulment on decisions, orders, and sentences of courts-martial which have already been served. That notwithstanding, I would order that all cases currently pending trial before the courts-martial be suspended forthwith. An injunction doth issue restraining the instigation, reopening, or continuance of the respondent's trial before the General Court-Martial or other courts-martial. I join issue with the recommendations or advisory orders proposed by the Honorable the Chief Justice. To these, I would humbly wish to propose a status of the offender determination in civilian courts. When the necessary legislative amendments have occurred, it should be imperative that prior to subjecting a civilian or person considered so by color of right before future courts-martial, a status of offender determination be made to the High Court of Uganda. Such investigation should be subject to the highest scrutiny, akin to extradition proceedings or movement of jurisdiction. The courts would have to be satisfied by an explicit demonstration that the interests of justice cannot be served in the ordinary courts of judicature. This standard would be applied to all matters in review. I further would propose to refer the proposals for amendments raised in Second Lieutenant Ogwang Ambrose versus Uganda, Supreme Court Criminal Appeal number 48 of 2021. The Supreme Court found that the UPDF Act in its current form creates a separate judicial system which has no recourse for appeal or judicial review to superior courts. The court called for legal reform and amendment of the UPDF Act in order to enable the courts of judicature to exercise their mandate of judicial review over the courts martial. In this regard, an amendment of the Uganda People's Defence Forces is required to confer appellate jurisdiction to the apex courts for them to be able to lawfully entertain appeals from the courts martial. The other question Ogwang raises is a requirement to delimit what a service offense is during peacetime. I propose that a soldier who commits a civilian offense when he is off post and away without pass leave or a wall should be arraigned before the civil courts, civil as opposed to military courts. The cross appeal succeeds. The main appeal succeeds in part. I make no order as to costs.
I call upon Lady Justice Elizabeth Musoka to deliver her judgment. You will please bear with her. I think she's got a little cold, so she needs your patience and understanding, my lord.
I hope you hear me. My voice is a bit hoarse. But this is a summary of my judgment. The judgment will be provided as the leader of this panel, the head of the panel will advise. The appeal and cross appeal in this case, again, is the decision dated 1st July 2021, rendered by the Constitutional Court. The quorum of Kakuru, Obura, Madrama, Musota, and Kasule acting judges of the Constitutional Court. That is Michael Kavaziguruka, Honorable, as Attorney General. The Attorney General is the appellant, stroke cross respondent, and Honorable Kavaziguruka is the respondent cross appellant, stroke cross appellant. The particulars relating to the declarations and orders sought in the respondent's petition, the issues identified for determination by the Constitutional Court and its decision on those issues, as well as grounds of appeal and those of the cross appeal, have been set out in detail in the judgment of the Honorable the Chief Justice, which I've had the opportunity to read in draft. I also had the opportunity to read the draft, the judgment of the judgment of Mugenyi, Justice of the Supreme Court. And in the interests of brevity, I'll straight away go into a discussion of the findings in my judgment. However, before giving my views, I should say that when the respondent filed his petition on 17th November 2016, he was challenging certain provisions of the UPDF Act of 2005. Under the 2023 revised edition of the laws, where the UPDF Act is now Cap 330, the numbering of many of the impugned provisions has changed, as indicated in the judgment of the Honorable, the Chief Justice. Nonetheless, in this judgment, I make reference to the numbering of the relevant provisions as set out in the respondent's petition and the judgment of the Constitutional Court. Although for future purposes, the numbering contained in the revised Act should apply. My judgment, and I said I'm giving a brief a summary of it. As I have indicated in my judgment, which you'll get, the grounds of appeal and cross-appeal, in my view, raise the following questions for this court's determination. Whether the 1995 Constitution places limits on the jurisdiction that Parliament can confer on the General Court Martial and the other military courts, and if so, what is the scope of those limits? Whether the jurisdiction conferred on the General Court Martial and other military courts under the UPDF Act goes beyond the applicable constitutional limits. Whether the General Court Martial is a subordinate court within the meaning of Article 129(1)(d). Whether the General Court Martial had jurisdiction to conduct the arraignment of the respondent, and if so, whether the arraignment contravened the respondent's right to a fair trial. Whether the General Court Martial and other military courts lack the capacity to render a fair trial, which is a non-derogable right guaranteed under Articles 28(1) and 44(c). And lastly, what are the appropriate remedies to grant in this case? My perspective on these questions is as follows. The first question being regarding the limits under the 1995 Constitution on the jurisdiction of the military courts. I find that the military courts are established as military organs of the UPDF under Article 2010A, and that the 1995 Constitution under Article 2010B limits the jurisdiction that Parliament may confer on any military court to only matters falling within the sphere of discipline and removal of members of the UPDF. This implies that the nature of cases that may be tried by the military courts are limited to disciplinary offenses committed by members of the UPDF, and the nature of punishment that can be imposed for such offenses is limited to the disciplinary sanctions, which are also provided, which are dismissal with disgrace, reduction in rank, forfeiture of seniority, suspension, severe reprimand, and caution. So for the analysis of the first question, you'll find that analysis on pages 2 to 10 of my judgment. Second question, in relation to the second question of whether the jurisdiction conferred on the General Court Martial and other military courts under the UPDF Act goes beyond any applicable constitutional limits, I find that it does in many respects as follows. First, in respect of Section 2 and Section 119(1)(a) to F of the UPDF Act, which conferred jurisdiction on the General Court Martial and other military courts to try members of the UPDF for offences under Part 6 of the UPDF Act. The jurisdiction goes beyond the sphere of discipline and removal of members of the UPDF within the meaning of Article 2010(b), insofar as the punishments prescribed for Part 6 offences are not only limited to discipline sanctions, the only punishments that can be imposed by military courts under 2010, but include serious punishments like the imprisonment and the death sentence. Second, in respect of Section 2 and Section 179, which confers jurisdiction on the General Court Martial and other military courts to try members of the UPDF for offences under the Penal Code Act and other enactments. The jurisdiction also goes beyond the sphere of discipline and removal of members of the UPDF within the meaning of Article 2010(b), in that punishments prescribed under the relevant laws are not limited to only disciplinary sanctions. The only punishments that can be imposed by the military courts under Article 2010. They include serious punishments like imprisonment and death sentence, as I said. Thirdly, in relation to Section 2 and Section 1191(g), which confer jurisdiction on the General Court Martial and other military courts to try non-members of the UPDF who are alleged to have aided and abetted members of the UPDF in commission of Part 6 offences. The jurisdiction goes beyond the sphere of discipline and removal of members of the UPDF within the meaning of Article 2010(b), in that the category of persons covered by this jurisdiction are not members of the UPDF, in respect of whom Article 210(b) was intended to cover. In addition, as with the first two categories, the jurisdiction goes beyond the sphere of discipline and removal of members of the UPDF because the prescribed punishments for Part 6 offences, which include the imprisonment and death, are more severe than the disciplinary sanctions which can be meted by the military courts under Article 2010(b). Fourthly, with respect to Section 1191(h), which grants jurisdiction to the General Court Martial and other military courts to try non-members of the UPDF who are found in possession of proscribed military equipment, this jurisdiction also goes beyond the sphere of discipline and removal of the UPDF, members of the UPDF, for three reasons. First, the persons affected are not members of the UPDF who fall within the jurisdiction of the military courts. Secondly, Section 1191(h) appears to be a penal provision, but it does not prescribe a punishment. And thirdly, the punishment for analogous offences under other laws include terms of imprisonment, which fall outside the nature of punishments that can be imposed by the military courts under Article 210(b), which are limited to disciplinary sanctions. In light of these observations, I find that Section 2, Section 119(1)(a) to (h), and Section 179 all grant jurisdiction to the General Court Martial and other military courts, which is inconsistent with Article 209A and 210B, and therefore, to the extent explained, unconstitutional and null and void. For the fourth category, which is provided for under Section 1191H of the UPDF Act, I find that it does not fall under the sphere of discipline of the UPDF, as it is neither concerned with members of the UPDF nor with disciplinary sanctions that can be given to members of the UPDF for engaging in unacceptable conduct. For analysis, the analysis of the above second question will be found on page 10 to 15 of my judgment. The third question, it's with respect to the question of whether the General Court Martial is a subordinate court. I note that Parliament is required to enact legislation under Article 129(1) for the creation of a subordinate court. But for the General Court Martial, Parliament moved under Article 210B with an intention to create a disciplinary body for the UPDF, not a subordinate court. I also find that, in any case, going by the provisions of Article 210B, the framers intended that military courts could only be established as disciplinary organs of the UPDF and could not be vested with a general judicial function so as to leave room for their establishment as subordinate courts. In addition, I find that a court can only qualify to be called a subordinate court if it's subject to the supervision of a superior court through revision proceedings. And note that the General Court Martial is not subject to the supervision of any of the superior courts under Article 129(1), including the High Court, Court of Appeal, or Supreme Court. And I conclude that on this account alone, cannot be stated that the General Court, in my view, that the General Court Martial is a subordinate court. I also find that it's not a subordinate court because it lacks essential features found in other courts of judicature, such as competence of its officers as legal professionals and lack of independence and impartiality. With all due respect, I propose the overruling of the dictum of Mulenga JSC in this court's decisions in Attorney General versus Joseph Tumushabe and Attorney General versus Uganda Law Society. Citations are given, in which Mulenga JSC expressed the view that the General Court Martial is a subordinate court within the meaning of Article 129D. Because in my view, that dictum was erroneous. I also point out that the Joseph Tumushabe case was concerned with the version of the GCM of the General Court Martial under the now repealed UPDF Statute number 3 of 1992, enacted before the coming into force of the 1995 Constitution, which makes it distinguishable since this appeal is concerned with the version created under the UPDF Act 2005. I therefore find that in the present case, this court does not have the same liberty to characterize the General Court Martial, since when Parliament enacted the UPDF Act, which provides for the current version of the General Court Martial, it could only establish a disciplinary body for the UPDF under Article 2010A and B. The third question The analysis of the third question will be found on pages 15 to 19 of my judgment. Now, the fourth question regarding the constitutionality of the respondent's arraignment. I note that in light of the position taken in my judgment, that under Article 2010B of the 1995 Constitution, the General Court Martial is limited to hearing cases involving members of the UPDF. And I take the view that since the respondent was not a member of the UPDF at the relevant time, his arraignment was unconstitutional. For the analysis on the fourth question, see page 17 of my judgment. Fifth question, in relation to the fifth question, whether the General Court Martial and other military courts lack the capacity to render a fair trial, which is a non-derogable right guaranteed under Articles 28(1) and 44C, I express the view, in agreement with the views expressed in the respective judgments of the Honorable the Chief Justice and Mugenyi, Justice of the Supreme Court, that there exists several deficiencies in the setup and operations of the General Court Martial that diminish its capacity to properly adjudicate cases. And these include objective lack of independence of both the General Court Martial as a court and of its members as individuals. The lack of competence of the members due to their lack of legal training and knowledge, and the absence of effective mechanism for reviewing the correctness of the decisions of the GCM, of the General Court Martial. I note that our Constitution was put in place to ensure a just, free, and democratic nation which encourages respect for people's fundamental rights, which was the reason for establishing the courts of judicature under Chapter 8 and vesting them with the mandate to exercise judicial functions fairly and do justice in all cases. I note that for criminal trials, the needs of justice require that accused persons are tried before competent courts or bodies that are capable of guaranteeing the right to a fair trial, and that, unfortunately, the deficiencies highlighted above render it impossible for an objective observer to conclude that the General Court Martial can guarantee the right to a fair trial. And as it is well known, a fair trial is a vital prerequisite for ensuring justice in criminal cases. Therefore, I find myself in complete agreement with the analysis and views of the Honorable Chief Justice and Genyi, JSC, on the deficiencies in the General Court Martial and how they render it incapable to accord a fair trial to the people that fall within its jurisdiction. In light of the highlighted deficiencies, I express the view that it is necessary not only to give a strained construction of the matters that properly fall within the ambits of discipline and removal of members of the UPDF, but also to ensure that as far as possible, offences are tried by courts of judicature, not military courts. I further express the view that it is therefore inappropriate to grant the military court's jurisdiction beyond the trial of members of the UPDF for disciplinary offences under Part 6 and the imposition of disciplinary sanctions as punishment for those guilty of disciplinary offences. All other criminal matters ought to be handled by courts of judicature. However, even in cases involving disciplinary offences under Part 6, there should be established a mechanism providing for revision of the decisions of military courts by the courts of judicature to ensure that the ends of justice are met. In my judgment, I exhort the learned Attorney General to take interest in the best practices set out in the respective judgments of the Honorable the Chief Justice and Mugenyi GSC, which represent the best reforms to improve the military court system. These are found on pages 19 to 20 of my judgment. In conclusion, and for the reasons given in my judgment, which you'll get, I would disallow all grounds of appeal and allow the sole ground of cross appeal. I would make I'll take on the declarations numbers 4, 5, 6, 7, and 9, and orders 1, 2, 3, 4, 5, and 7 contained in the judgment of the Honorable the Chief Justice, since they are consistent with the findings in my judgment. I would also commend the Honorable Chief Justice's advisory orders to the attention of the learned Attorney General. I would then make the following separate declarations arising from the findings in this judgment, in addition to the ones I have pointed out above contained in the judgment of the Honorable the Chief Justice. Number 1, General Court Martial is not a subordinate court within the meaning of Article 129(1)(d) of the 1995 Constitution. General Court Martial and other military courts are disciplinary organs of the UPDF established under Article 210, whose jurisdiction is limited by Article 210(b) to handling matters related to discipline and removal of members of UPDF, including former and assimilated members of the UPDF, as stipulated under Section 1191A to F of the Act. Number 3, the jurisdiction of the General Court Martial and other military courts is under 210B, limited to hearing matters involving disciplinary offenses under Part 6 of the UPDF Act, committed by members of the UPDF as defined in paragraph B, and is also limited to the imposition of disciplinary sanctions to the members of the UPDF found guilty, as I have already stated. I enumerated the offense, the punishments earlier on. Jurisdiction of the General Court Martial and other military courts does not extend to hearing cases involving civilians who are neither former or assimilated members of the UPDF, as defined in paragraph B. The hearing of cases involving civilian non-members of the UPDF falls within the jurisdiction of courts of judicature established under Chapter 8 of the 1995. The hearing of cases involving members of the UPDF, as defined in paragraph B above, for the commission of offenses under Part 6 of the Act, where it is appropriate to impose a sentence of imprisonment or a more serious sentence, falls within the jurisdiction of courts of judicature established under Chapter 8. The hearing of cases involving members of the UPDF, as defined in paragraph B above, for the commission of general civilian offenses created under any enactment other than Part 6 of the UPDF Act, falls within the jurisdiction of the courts of judicature established under Chapter 8, the Constitution. Section 2, 1191H and G, and Section 179 of the UPDF Act, in as far as they confer jurisdiction on the court martial and other military courts to the constitutional limits, contrary to the constitutional limits described above in this judgment, are unconstitutional and null and void. I would make the following orders, in addition to the ones which I adopt from the Honorable the Chief Justice, which are in his judgment orders, in the draft judgment which I read, There were orders 1, 2, 3, 4, 5, and 7. I would just add that going forward, only cases involving members of the UPDF and related to disciplinary offences under Part 4 of the UPDF Act should be tried by the General Court Martial and other military courts, and that only the disciplinary sanctions as described at C above can be imposed by the military courts in those cases. Number 2, where a military court determines that the imposition of a more serious punishment, such as imprisonment or the death sentence, is necessary, in addition to removal from service, the military court shall forward the case filed to the Director of Public Prosecutions with a recommendation for institution of criminal proceedings in a competent court of judicature. I'll adopt the order made by the Chief Justice on the respective effect of or otherwise of this judgment. Otherwise, I would award costs of the appeal and the cross appeal in this court and the costs in the Constitutional Court to the respondent.
Now we will now have Honorable Justice Mike Chibita deliver his judgment.
Thank you, Honorable Chief Justice, my lords, ladies and gentlemen. I have read the lead judgment of Winyidolo Chief Justice in draft. On the whole, I agree with the spirit, findings, declarations, recommendations, and orders. Before delving into the substance of the judgment, let me deal with one preliminary point of public interest. As one of the surviving members of the original panel that first heard this matter, I reiterate the explanation that unprecedented occurrences indeed hindered and stood in the way of the expeditious disposal of this appeal. The retirement of Honorable Justice Ezekiel Mhanguzi and the deaths of Honorable Justices Opio Awiri and Stella Rach Amoko, all of whom were members of the original panel, ensured that reconstitution of the panel was inevitable. It was not until Honorable Justices Catherine Bamugemereire and Monica Mugenyi, Justices of the Supreme Court, were appointed in 2024 that a full panel could finally be reconstituted. Suffice to say that any delay in dispensing justice is always regrettable, whatever the cause. The larger principles at play in this case are the age-old principles of the jurisprudence of criminal law. It is universally accepted in the common law system to which Uganda subscribes that the presumption of innocence is a bedrock of our criminal law. And this has been incorporated in the 1995 Constitution of the Republic of Uganda under Article 28(3)A, which states that every person who is charged with a criminal offense shall be presumed to be innocent until proved guilty or until that person has pleaded guilty. In other words, everybody is presumed innocent until proven guilty by a competent court. What we are investigating in this case is whether the court-martial is a competent court to try civilians or anybody else brought before it for that matter. Other guarantees of justice and fairness in criminal proceedings are the right to a fair trial and the right to a fair hearing as stipulated under Article 28(1) of the said Constitution, which reads, in the determination of civil rights and obligations or any criminal charge, the person shall be entitled to a fair, speedy, and public hearing before an independent and impartial court or tribunal established by law, close quotation. So the question is, does the General Court-Martial guarantee these fundamental freedoms? The answer, as far as civilians are concerned, has been found to be largely in the negative. In accordance with the doctrine of precedent and in view of an earlier holding by this court, the conclusion in Attorney General versus Joseph Tumushabe that the General Court Martial is indeed a subordinate court as contemplated under Article 129(1)(d) of the Constitution is still good law. Secondly, that Section 117(1)(g) of the UPDF Act does constitute exceptional circumstances under which the trial of civilians in military courts would be justified, and to that extent is not inconsistent with Articles 28(1) and 44(c) of the Constitution. However, I agree that Section 117(1)(h) of the Act is to be found void for vagueness and therefore inconsistent with Article 28(1) of the Constitution. On the issue of remedies regarding matters pending before the General Court Martial involving civilians, I would agree that they will be remitted to the civilian courts for consideration. And in regard to trial of members of the military, I agree with the recommendations given to the executive and parliament to work on the necessary amendments in order to bring the court martial in conformity with the Constitution. I'm persuaded by the doctrine of prospective annulment as opposed to retrospective annulment as laid down in the case of Kalista and Rumwatela and two others against the East African community, which was applied in the case of Bob Kasango against Attorney General. The same principle was held in the case of East African Law Society and four others against Attorney General of Kenya and three others. The court declined to invalidate amendments found to violate the treaty. Court, however, invoked prospective annulment and declared that involvement of the people in the treaty amendment process would have prospective application. In the case of A against the governor of Abba Hill Prison, the Supreme Court of Ireland held that the declaration of unconstitutionality of a law has prospective effect only. It was further held that the court cannot interfere with final decisions of the courts, even if based on a law later to be found unconstitutional. Otherwise, retrospective annulment or retrospective effect, as termed elsewhere, would create an absurdity which the courts can and should never intend. Dated at Kampala, the 31st day of January, 2025.
Now we can ask Lady Justice Twice to deliver her judgment.
Thank you, my Lord. Thank you, my Lord Chief Justice. I will proceed to read my judgment as follows. I have had the benefit of reading in draft the lead judgment by Alphonse C. Owindolo, Chief Justice. I agree with the analysis, decisions, conclusions, and orders that are proposed in his lead judgment. The background to this appeal and the respective cases for the parties to the suit have been ably articulated in the lead judgment and in other judgments prepared by my land sisters and brother in this appeal, which I have also had the benefit of reading in draft. It is therefore not necessary to reproduce the same. I will only add my opinion regarding the issue relating to the capacity of the I will only add my opinion regarding the issue relating to the capacity
of the General Court Martial to render a fair trial as envisaged in Article 28(1) of the Constitution of Uganda. The jurisdiction and competence of the said court is challenged by the respondent in this appeal. The appellant, on the other hand, contends that it is a court of competent jurisdiction provided for under Article 210 of the Constitution of Uganda and Section 197, now 195 in the revised edition, the year 2023 of the Uganda People's Defense Forces Act. The appellant also, in opposition to the respondent's assertions, contends that the establishment of the General Court Martial does not contravene Articles 28(1), 126(1), 129(1), 210 and 267(1)(d) of the Constitution of Uganda. The General Court Martial is created under Section 197, now Section 195 in the revised version of the laws of Uganda, of the Uganda People's Defense Forces Act. Its long title reads, among other things, that it is an act, I'm quoting, to provide for the regulation of the Uganda People's Defense Forces in accordance with Article 210 of the Uganda Constitution and for other related matters. It is a specialized court in the sense that it was created to exercise jurisdiction over specified matters relating to offenses created by the UPDF Act, committed by members of the military forces and persons who aid or abet such offenses. In short, to administer military justice in Uganda with jurisdiction to handle offenses specified in the Act, mainly for penal and disciplinary purposes. The General Court Martial was therefore established as a specialized court of the military forces. On the other hand, the Constitution also establishes courts of judicature empowered to exercise judicial power with various jurisdictions under Article 129 of the Constitution, which states that the judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of A, the Supreme Court of Uganda, B, the Court of Appeal of Uganda, C, the High Court of Uganda, and such subordinate courts as Parliament may by law establish, including Cadiz courts for marriage, divorce, inheritance of property, and guardianship, as may be prescribed by Parliament. To the Supreme Court, the Court of Appeal, and the High Court shall be superior courts of record, and shall each have all powers of such court. And 3, subject to the provisions of this Constitution, Parliament may make provisions for jurisdiction and procedure of the courts. Both the courts martial and the courts of judicature therefore have their origins from the Constitution, save that while the Constitution directly sets up the courts of judicature under Article 129, The courts martial are set up by an act of parliament as mandated under Article 129(1)(d) and 210 of the Constitution. The criteria for appointment of members who sit on the General Court Martial set out under Section 195 in the revised version of the laws of Uganda 2023 of the UPDF Act is that they should essentially be army officers, with the chairperson not being below the rank of a lieutenant general. Save for the chairperson of the court of the Court Martial Appeal Court, who is required to be an advocate, qualified to be appointed as a judge of the High Court. Legal qualification is not a basis for appointment on the General Court Martial and the other military courts set up under the UPDF Act. In contrast, under Article 143 of the Constitution of Uganda, persons qualified for appointment as judicial officers to the courts of judicature as established under Article 129 of the Constitution of Uganda must have legal qualifications. It is to be noted that both the General Court Martial and the courts of judicature, particularly the superior courts, under the respective laws that govern them, as well as the penal laws, either in the exercise of their original or appellate jurisdiction, are empowered to pass the death penalty, which is the maximum punishment a court of law would pass. It is also noted that under Article 123B of the Constitution of Uganda, the Director of Public Prosecutions, who is the officer charged with the function of, among others, instituting criminal proceedings against any person in that court, is exempted from instituting such criminal proceedings in a court martial. The contradictory position is that while under the UPDF Act, qualification for appointment to the General Court Martial does not require one to have legal qualifications, persons qualified for appointment to the position of a judicial office in the courts of judicature are required to have legal qualifications under Article 142 of the Constitution. Secondly, the conducting of criminal trials in the General Court Martial, unlike in the case for courts of judicature, is not controlled by the Director of Public Prosecutions. The interests of justice and fairness require that any court that is empowered to pass a penalty for a penalty as serious as a death penalty, or even, I dare say, imprisonment, should be presided over by competent persons with legal qualifications. The criminal prosecutions conducted before such courts should ideally be controlled by the Director of Public Prosecutions. This would be a safeguard for a fair trial envisaged under Article 28(3) of the Constitution of Uganda. in addition to the International Covenant on Civil and Political Rights, to which Uganda is signatory, and all other international human rights instruments, binding or persuasive, which have been ably highlighted in the other judgments to this appeal. In my considered opinion, it would not matter whether in actual fact, that is de facto, the members appointed to sit on the General Court Martial, in the wisdom of the appointing authorities, do possess the legal qualifications to be competent to adjudicate criminal matters, especially those attracting heavy penalties. As long as the UPDF Act that creates the General Court Martial does not expressly include legal qualifications as a requirement for appointment to the General Court Martial, that is de jure, the competence and capacity of that court to handle criminal trials would still be questioned as is being done in this appeal. This is based on the cardinal principle in our legal system that justice must not only be done, it must be seen to be done. The General Court Martial would only be competent to adjudicate over criminal matters of not only civilians, but also military persons, if it were a court of law with the requisite structures to conduct a fair hearing, as envisaged under Article 28 of the Constitution of Uganda. There can be no fair trial as envisaged in Article 28(1) of the Constitution in an incompetent court. It is in that regard I would, with respect, not agree with the appellant's contentions that the General Court Martial is a court of competent jurisdiction to hear criminal matters. In its present state, the General Court Martial, though lawfully set up by an act of Parliament, deriving such powers from Article 129(1)(d) of the Constitution, is in its present form competent only to handle matters relating to discipline of members of the armed forces. In the result, based on the above, and in addition to the reasons, decisions, conclusions, and recommendations for legal reforms stated in the lead judgment, which I associate myself with, I would conclude that this appeal fails, save for the issue regarding the establishment of the General Court Martial as a court of law. I would dismiss it to that extent and allow the cross appeal. I would award the course of this appeal to the respondent in this court and in the courts below.
Thank you, my lord. I propose we take a 10 minutes health break.
Yes, my lord.
Yes, because 200 pages will take us up to midnight, I think. So, okay. So 10 minutes break, health break, yes.
My Lord, still the same Supreme Court Constitutional Appeal number 2 of 2021, the Attorney General versus Honorable Mike Okuwa, and it's up still for judgment, and the quorum is still the same, my Lord.
After wise counsel, I've decided to summarize my judgment. So I'll read a 35-page summary of the judgment, so you don't have to worry that you'll stay here overnight. We will, of course, before the close of business today, have all counsel receive the soft copy in your email, in your respective email. Yeah. Yes, and but before I go into my summary of judgment, I need to read the judgment of Lady Justice Faith Mwanda, who retired and left the services of the judiciary in July last year. But before she left, she perused the draft judgment of the Chief Justice, and she was in total agreement. So I'm reading her concurring judgment, then I go into mine. So this is judgment of Faith Mwanda, Justice of the Supreme Court. I have had the benefit of reading in draft the judgment of my learned brother, Owindolo CJ. I concur with the analysis and the decision made. I also concur with the proposed orders as embodied in his lead judgment. I have nothing useful to add. Signed by Lady Justice Faith Mwanda. So this is the summary of my judgment. Even here, I will not read everything. I'll read the core part of the summarized judgment. So it headed summary of the judgment of Owindolo CJ. It's not Owinyi, it is Owindolo. Introduction. This appeal arises out of a petition instituted under Article 137, Clause 1 and 3 in the Constitutional Court. In essence, the appeal and cross-appeal are against the majority decision of the learned justices of the Constitutional Court regarding the competence of the military courts, their ability to render a fair hearing, the offenses triable in military courts, and persons subject to the jurisdiction of the military courts in Uganda. The background. When he filed constitutional petition number 45 of 2016 in the Constitutional Court, the respondent was a civilian and member of parliament representing the people of Nakawa Municipality, Kampala Capital City Authority, KCCA, in the 10th Parliament, and a shadow minister for KCCA. He filed the petition against the backdrop of events following his arrest, where he was arraigned before the General Court Martial, GCM, and charged along with others with offenses under the Uganda People's Defense Force (UPDF) Act. To wit, offenses relating to security contrary to Section 130, subsection 1, paragraph F, with the particulars thereof being that he contrived a plot with others to overthrow the government of Uganda, and treachery contrary to Section 129A, with the particulars thereof being that he infiltrated the UPDF or was an agent of a foreign power or any force engaging in war or warlike activities against the government of Uganda. He objected to his trial in the GCM, contending that he was not subject to military law as he had no military connection, and that the GCM was not a competent court under the Constitution to try any of the offenses with which he was charged. But the GCM overruled his objection. He filed a petition in the Constitutional Court challenging the provisions of the UPDF Act number 7 of 2005, which he singled out in the petition, and acts of the UPDF of arresting, detaining, and remanding him to prison in relation to the charges against him, as being inconsistent with the Constitution. The proceedings in the GCM against the respondent were stayed by an order of the Constitutional Court. He prayed for a permanent injunction to restrain the appellant from continuing those proceedings. The Constitutional Court partly allowed the appeal in its majority decision, where it inter alia held that as a civilian, the respondent was not subject to military law and could only be lawfully tried by a military court if he were charged under Section 119, subsection 1, paragraph G of the UPDF Act, as an accomplice to a principal who was subject to military law. And the principal was so named in the charge sheet. There being no principal named in the charge sheet, the court held that the charges brought against him were null and void and of no effect. The court also declared Section 119(1)H of the Act, which allowed military courts to try persons for offenses provided for under other laws outside the scope of the UPDF Act, unconstitutional. According to the court, Parliament never intended that the UPDF Act should be an act of general application, since it is a statute of special and limited application. Hence, the unlimited and original jurisdiction of the GCM referred to in the UPDF Act only apply to offenses under the Act. Last, the court examined the nature of the military courts and held that first, military courts lack all the tenets of an ordinary court established under Chapter 8 of the Constitution, particularly under Article 28(1). Second, they are tribunals, and third, they are not part of the judiciary. The court accordingly ordered the petitioner to be released forthwith. The appellant was dissatisfied with the decision of the Constitutional Court, hence it appealed to this court. The respondent, for his part, cross-appealed against the decision, allowing civilians in certain cases to be tried in the military courts. The grounds of appeal are: 1, the learned majority justice of the Constitutional Court erred in law in finding that Sections 2 and 179 of the UPDF Act are in contravention of Articles 28(1) and 44C of the 1995 Constitution, and that the GCM is only competent to try military disciplinary offenses under Part 6 of the UPDF Act. 2, the learned majority justice of the Constitutional Court erred in law and fact in determining that the GCM cannot be impartial or independent, is inconsistent with Article 28(1) of the 1995 Constitution of Uganda, and does not apply the principles therein to persons subject to military law. 3, the learned majority justices of the Constitutional Court erred in law and fact in determining that charging and arraigning the petitioner before the GCM was inconsistent with Article 28(1) and 44(c) of the Constitution. 4, the learned majority justices of the Constitutional Court erred in law in finding that Section 1191H of the UPDF Act is inconsistent with Article 28(1) and 44(c) of the Constitution. The appellant prayed that the appeal be allowed. The decisions of the learned majority justices of the Constitutional Court cited be set aside, and the appellant be awarded cost of the appeal. The cross appeal. The respondent cross appealed on the following one ground: that the learned majority justices of the Constitutional Court erred in law in holding that a civilian can be charged before military courts as an accomplice together with a person subject to military law. He thus prayed that the cross appeal be allowed, and part of the decision of the majority justices that he has impugned be set aside or reversed. Consideration and determination of the appeal by this court. The appeal first came up for hearing in this court in 2022. From that time to its final disposal today, it has suffered an unprecedented affliction by a host of adversities. There is thus an imperative need to clarify on what transpired within that period. The grave and persistent series of events that characterized the lifespan of this appeal began with the fire gutting the chambers of the Chief Justice on the Supreme Court building at Kololo on the 27th April 2022, followed by water flooding parts of the building. This resulted in a condemnation of the Kololo Supreme Court building as being unfit for occupation, thereby leaving the justices of the court with no office accommodation. Thereafter, 2 justices of the court, namely Justice Paul Mugamba and Justice Ezekiel Mwanguzi, who were part of the original panel for this appeal, retired. This therefore necessitated a reconstitution of the panel. In November 2022, the court was able to secure a temporary home, and more justices were appointed to the court. The court then embarked on the process of reconstitution of the panel, with a view to sitting by December that year to rehear the appeal. However, that December, we suffered the devastating demise of Honorable Justice Ruby Awere Opio, who had been on the original panel for this appeal. This necessitated awaiting the appointment of additional justices of this court for the requisite reconstitution of the quorum to take place. However, in only 6 months thereafter, yet another tragedy struck this court with the demise of Justice Stella Arach Amoko in June 2023. It was until January 2024 when 2 more justices were appointed to the Supreme Court, whereafter the court was able to reconstitute the panel for this appeal. The appeal came up before the reconstituted panel on 13th May 2024 in the new Supreme Court building at the Judiciary Headquarters, upon which the learned justices reserved judgments to be delivered on notice. Notice has been served on the parties for delivery of the judgment today, and that's why you are here. So the delay in this case did not take 4 years, as some people, including members of the learned profession, have dishonestly been feeding the public. Judgment in this case delayed by 8 months, from May last year to today. If you did some arithmetic at school, you'll find this is 8 months, not 4 years. Yeah. But let me say this also. This is a court of law, court of judicature. The court does not belong to the Chief Justice, does not belong to the justices and judges of the various courts of judicature. It belongs to all of us. It's our property. It belongs to you and me. If you're part of those who bring politics, come to play their politics in this court, you're fighting yourself. You're piercing your own eyes with your fingers, with your nails. Because for as long as you live, we'll need this court. The court you're trying to delegitimize, the court you're throwing mud on, is the one you will run to. That's not to say courts, judicial officers should not be criticized. As a matter of fact, if people do not criticize, it means you're doing nothing, and they ignore you. Criticism makes the best out of a person. But please, what you can do in the political field, and some of us have been there, should be different, whether you're a lay person or you masquerade as a lawyer. Please, this is your home, and for many of you, this is your marketplace. Let us use constructive criticism. Let us engage with the Chief Justice, with the judicial officers, with the administration of the judiciary, so we have a better institution. Each time we improve on it, because this is like a hospital. At some day you must go to a medical center. So you will come here, your relatives will come here, anyone who seeks justice will come here. So if your purpose is to destroy the judiciary as an institution, it's like democracy. You may not know the worth of democracy until it is taken away from you. It's like the oxygen, the air we breathe. Many times we take air for granted until somebody closes your nose, then you know how important air which we take for granted is. So my appeal is, speaking for myself and then on behalf of the judicial officers, criticize me every day, walk to my chambers and say, Mr. Chief Justice, how can this be? Write to me, because it's not my property. It belongs to all of us. But this idea of thinking that you can gain fame, you want to be known, you learn how to write in social media, thinking you are attacking the Chief Justice, you are attacking yourself. And I ask all these people, please read A Man for All Seasons. You are cutting that forest which you'll need when the devil begins chasing you. So I thought I should say this and then read my judgment. But also let me add, let nobody go fearing that, oh, I have stepped on the foot of the Chief Justice, now he's going to bear ill will against me. No, we as judicial officers, we have taken the type of oath you have not taken. We've taken the oath never to fear, including never to fear criticism, never to favor, never to be driven by affection, and most importantly, in the circumstance of this case, never to bear ill will against even those who have thrown mud at us, because that is the beauty of being a judge. Meaning, if we can sum up that oath, we must be guided by our conscience. That's really what it is saying. So if you've stepped on my toe, don't fear me. Come to me tomorrow, come to my home. I bear no ill will, and none of the judicial officers bears any ill will. But I also hope that you will have the courage to say sorry. Some of the things that have come out of members of the learned profession, unthinkable. So learn to say sorry. Just you don't have to say it to me, but some of my judicial officers, please say sorry to them, because they are doing this for you. The power comes to you, comes to us from you, because you're part of the people of Uganda. So having said that, let me now go into my consideration of the merit of this appeal. This court has been called upon to clarify the constitutionality of several aspects of the law concerning military trials. Even if the arguments gravitate around trials in the General Court Martial, the points raised radiate to the whole military court system. I note that the 4 grounds of appeal and the one in the cross appeal raise cross-cutting issues. And this explains why some submissions by counsel on a particular ground were as well reiterated in other grounds. All the grounds contained an element of counter to the challenge raised against the competence of the General Court Martial and know its status as a court of law. Whereas the standing of the General Court Martial as a court of law was not raised as a separate ground of this appeal, and yet it was a separate question for determination in the Constitutional Court, upon which the court rendered a decision declaring them to be tribunals. It was implicit in all the grounds of appeal that it was an issue. In determining this appeal, therefore, I adopt an integrated approach where a ground may be disposed of in the course of considering another ground. For instance, the status of the General Court Martial as a court has a bearing on the resolution of grounds 3 and 4, which entail the determination of the issues of personal and subject matter jurisdiction of the court respectively. During the period after hearing this appeal, the laws of Uganda were revised. The UPDF Act is now cited as the UPDF Act, Chapter 330, while the impugned sections 2, 119, 1H and G, and 179 have changed to sections 1, 117G and H, and 177 respectively. However, there is no change in the content. In this appeal, I consider that the issue of the establishment of a court of law, its subject matter or personal jurisdiction, its structure and the fairness of its procedures, and the exercise of judicial power are distinct questions. In that regard, the specific issues for this court to resolve arising out of the Constitutional Court decision, the grounds of appeal and cross-appeal are: 1. Whether the courts martial are courts of law duly established under the Constitution or are tribunals. 2. Whether the courts martial can be or are independent and impartial within the meaning of Article 28(1) of the Constitution. 3. Whether civilians can legally, that is without offending the Constitution, be liable to face trial in the courts martial for disciplinary offenses, hereinafter called military, disciplinary, or service offenses, stipulated in Part 6 of the UPDF Act. 4. Whether civilians can constitutionally or legally be tried in the courts martial for civil offenses not comprised in Part 6 of the UPDF Act, but are instead provided for in other legislations. 5. Whether it is constitutional for persons subject to military law to be tried in the courts martial for offenses outside the UPDF Act, hereinafter called civil offenses. 6. Whether it is constitutional for civilians to be tried by the courts martial as principals for offenses under Section 119(1)H of the UPDF Act, yet these also exist as civilian offenses. This court is aware of the rules of constitutional interpretation and has set them out in detail. You'll find I've set them out in the main judgment. This is a detailed coverage. Counsel for both parties have, in support of their cases, cited several Ugandan authorities. These include Second Lieutenant Okuwa Ambrose against Attorney General, Sergeant Paul Kalemera against Attorney General, and others. Other relevant authorities that have also been delivered since the hearing of this appeal, and upon which counsel in this petition have had no opportunity to submit on, are retired Captain Amon Biarugaba and 169 others. The Second Lieutenant Okuwa Ambrose of Uganda, this is another decision for the lieutenant, It thus falls on this court to ensure certainty in the application of the law by clearly spelling out the principles that should guide on how to structure and how handle matters concerning discipline in the UPDF. This will ensure that the provisions of Article 209 of the Constitution are given effect to, without affecting other provisions of the Constitution. It will also ensure that the enforcement of the provisions of Chapter 4 of this Constitution. Ground 1 is the General Court Martial lawfully established as a court of law. Under Part 8, titled Military Courts, the UPDF Act provides for the Summary Trial Authority, STA, Unit Disciplinary Committees, UDC, and Courts Martial. From the outset, it is clear that the STA and UDC are not established as courts, but as tribunals. The Courts Martial, established at the Division Court Martial, established under Section 196, which is now 192, the General Courts Martial under Section 197, which is now 195, and the Court Martial Appeal Court, established under Section 199, which is now 197, and the Field Court Martial under Section 200, now 198. It is clear that the long title provides that the Act is passed under Article 210 and not 129(1)(b). However, I do not consider that failure to indicate Article 129 instead of 210, as was done in the long title of the UPDF Act alone, is enough to take away Parliament's power given to create a court under Article 129(1)(d). The General Court Martial is part of the courts of judicature referred to under Chapter 8, albeit with a special limited jurisdiction. The other argument for consideration is whether the creation of a court under Article 129(1)(d) requires an amendment of the Constitution and or a referendum. Under Article 259 of the Constitution, an amendment of the Constitution can only be done by an Act of Parliament whose sole purpose is the amendment of the Constitution and pursuant to the requisite parliamentary procedure for such amendment. I have duly given consideration to the provisions cited, Article 129 that establishes the Court of Judicature, Article 128 that provides for the independence of the judiciary, and Articles 259 and 260 do not stipulate that the creation of a subordinate court per se requires an amendment of the Constitution. Article 129 merely lists the courts of record and provides that the creation of other subordinate courts shall be as established by laws made by Parliament. The UPDF Act is one of those laws, and Section 197(1), now 195(1) thereof, establishes the GCM. It is also evident that the Constitution contemplates the existence of courts martial. See, for instance, Article 2572A and Article 203B of the Constitution. It was contemplated that owing to the unique nature of military work, matters of military discipline should be handled by special courts, court martials in bracket, and military tribunals, UDCs and STAs. The issue whether the General Court Martial is a court was conclusively settled on the General against Tumushabe and Attorney General against Uganda Law Society. It would, however, do well if Parliament clearly stipulates in the law enacted the status of a court created as the Magistrates Court Act does. I note that in Attorney General against Tumushabe, this court came to the conclusion that since the GCM exercised judicial power, it is or must be deemed to be a court. To the contrary, my finding is that the legality of the establishment of the General Court Martial, not based on its exercise of judicial power, but on the authority conferred on Parliament under Article 129, 1D of the Constitution. Exercise of judicial power and tribunals. Before I take leave of this issue, I would like to address myself to the aspect of the exercise of judicial power by courts and military tribunals, upon which the learned justices of appeal based their decision in retired Captain Amon Biarogava. As a general rule, in a democratic society or dispensation, every aspect of judicial power must be exercised by a competent authority established by law. Judicial power, which is exercised by the judicial arm of government as an institution, as is provided for in the Constitution, refers to the authority vested in the courts of judicature, whose judicial officers interpret and apply the law, resolve disputes, and administer justice generally. In a narrower sense, judicial power generally uniquely involves an exercise of power to interfere with the personal liberty of persons who appear before it. And this usually falls exclusively within the realm of ordinary courts of law, although there is no express bar to criminal exercise of jurisdiction by some tribunals. Tribunals usually exercise quasi-judicial power as opposed to judicial power of the courts. As a characteristic, the moment an entity can hear criminal cases and give custodial sentences or detain its suspect during hearing, the entity exercises judicial power regardless of its title as a court or tribunal. In other words, the exercise of judicial power is not in all cases what differentiates a court from a tribunal. I have noted that under the UPDF Act, the UDCs and STAs, UDC is Unit Disciplinary Committee, in case you had forgotten, and STA is the Summary Trials Authority, that are established as tribunals, have been given jurisdiction to try offenses, and sentences that they can impose range from caution to custodial sentence. Pursuant to Articles 23, 126.1 and 129.1 of the Constitution, it is only the courts that are granted the mandate to interfere with personal liberty in the sense of custodial sentences or any legal detention of a suspect for an extended period of time during a hearing. Therefore, in the Ugandan framework of military courts, it is only the courts martial that are established as courts of law under the Constitution that can properly or legally be said to exercise judicial power when hearing offenses, criminal or disciplinary, with the power to impose custodial sentences and detain suspects. The UDCs and SDAs are tribunals. Hence, whatever judicial powers they exercise are unconstitutional, as they do so without lawful authority. Ground number 2. Every court established under the Constitution must meet the criteria for a fair hearing. Similarly, tribunals entrusted with judicial power have to apply the principle that ensure a fair hearing, and for this, the classification as courts or tribunals bears no relevance. The right to a fair hearing is one of the fundamental human rights that are considered an imperative in any trial. See Article 28.1 of the Constitution of Uganda as amended. The UDHR, Article 10 of the UDHR, Article 14, Paragraph 1 of the ICCPR, Article 7 of the African Charter. The guarantees of the right to a fair trial applies to all courts and tribunals, including military and other specialized courts. The principle of equality. Judicial power, even though it is limited in jurisdiction, has been devolved to military courts be exercised in line with the Constitution, while respecting the fundamental rights and freedoms of individuals appearing before them. It goes without saying, therefore, that all persons, including military personnel or persons subject to military law, are entitled to the non-derogable right to a fair hearing. Although a soldier becomes subject to the military system, he does not cease to be a citizen, and his rights as a citizen remain relevant, albeit in an amended form. But whatever legislation is applicable, it must still be interpreted in light of the supreme law. Can a military court be independent, fair, and impartial? A military court can be independent, fair, and impartial. Thus, trial of a person by court-martial does not per se occasion a violation of the person's right to a fair hearing provided for under Article 28(1) of the Constitution. That provision does not specify the composition of or procedure adopted by such a court or tribunal, other than listing the procedural safeguards required for a fair hearing. However, as noted earlier, Article 128 of the Constitution also imposes a requirement as to objective independence of the court or tribunals exercising judicial power as a safeguard to a fair hearing. Proof. An individual who challenges the independence of a tribunal need not prove an actual lack of independence. See the case of General Oaks. In a particular case, the challenge can touch on the whole structure and procedure of the courts. Similarly, this is an objection to the system of trial within the General Court Martial in its current structure. Test for independence and impartiality. What may be considered to pass the test for independence and impartiality and thus ensure a fair hearing in military courts has been a subject of wide consideration and discourse. With regard to independence, Article 128(1) of the Constitution provides that, quote, in the exercise of judicial power, the courts shall be independent and shall not be subject to the control or direction of any person or authority, close quote. Article 128, clauses 2 to 8 are all provisions geared towards ensuring and maintaining this independence. To determine whether the courts-martial or the persons manning the courts are independent in the exercise of their judicial powers requires an examination of the laws and procedure under which the courts operate. From this, one can then determine whether a reasonable person familiar with the Constitution, the laws setting up the military courts and their structure would perceive and be satisfied that these courts are independent. Counsel for the appellant emphasized that fairness in the General Court Martial is assured because the members of the General Court Martial take an oath to uphold the Constitution and administer justice. Indeed, it is the norm that judicial officers take an oath to render justice, and this places the duty on the respective judicial officers to exercise the judicial power with independence of mind and impartiality. However, this subjective undertaking of exercise of duty is only truly guaranteed when it operates alongside the objective safeguards that can satisfy a reasonable person that the appearance of partiality is eradicated, and the judicial officer is acting with an independent mind and is insulated from extraneous factors such as an undue influence. Impartiality is determined by the absence of bias, objective or perceived. In this regard, objective impartiality is akin to independence. The test for impartiality is, open quote, whether a reasonable, objective, and informed person acting on the correct facts will reasonably apprehend that the judge has not or will not bring an impartial mind to bear on the adjudication of cases, close quote. C, in re an application for recusal of Honorable Justice Alphonse Chigamoyo Windolo, Chief Justice, miscellaneous application number 3 of 2021, arising from presidential election petition number 1 of 2021, Chagulanyi Sentamu Robert against Yoweri Kaguta Museveni, Tibuaburwa, and 2 others. It is clear that in impartiality, appearances are of importance in order to satisfy the subjective requirements. See also the case of R against Spear and Findlay against UK. In the instant case before this court, the respondent makes no allegation that the members of the tribunal were actually biased. I would thus recast the issue of independence, impartiality, and impartiality of the members of the court as follows. Whether a fair-minded and informed observer would conclude that the safeguards for a fair hearing in the court-martial were adequate to guarantee the independence and impartiality of members of the court-martial. What is manifest from an examination of our laws is that, with regard to courts-martial, 1, with the exception of the CMAC, Court-Martial Appeal Court, there is no legal requirement for a person qualified in law to form part of the quorum. Before I proceed, I wanted to understand that apart from the Court-Martial Appeal Court, the others who sit and carry out judicial function, there's no requirement for them to study law, to be lawyers. So it's like there's no requirement for anyone to go to a theater and operate on a patient. You can pick the most famous lawyer in town and give him those knives, I don't know how they call them. Or you can pick the Chief Justice of Uganda, give him 12 people, not even all 12 people. He would have been carrying the rank of a corporal in charge of a section, and you place him at the board of DRC to protect Uganda against possible enemies. He has never touched the trigger of a gun in life. He doesn't know map reading. He doesn't know how to win civilians to his side. He did not have the 9 months training that is required, the basic training that makes you be a soldier and get the first rank of private, I think the first rank of recruit. Or you ask any professor from Makerere University and say, look, we are giving you a Boeing 474, you fly it to Addis Ababa. These are not jokes. Yeah. The importance of professional training to be able to do something. Order in the court. The importance of professional training to be able. And in this, nobody is saying, even the respondent, when he brought the petition, he's not saying Major so-and-so or Colonel so-and-so was biased. He's not saying that. Or that he's just saying, look, these people do not have the training to be judice officers. And they try treason, they try all sorts of things. But when the LC Courts Act, the law that placed the LC Courts, because they knew that the LCs were not trained in the law, they were not given jurisdiction over to criminal matters. Not even theft of chicken, by the way. They were not given jurisdiction. So the first one is legal training. 2, the judge advocate's role is entirely advisory, as he or she does not form part of the court that deliberates on the verdict and sentence. So the judge advocate acts like an assessor whose view does not bind anyone. 3, decisions are by majority opinion of members of the court. The courts are convened and the members are appointed by the High Command or some other authority delegated by the High Command. They are not appointed by an independent institution. The commanding officer of the brigade probably would appoint who sits in the divisional court-martial. The courts comprise military men with no differentiation as to whether they are active, about to retire, or have retired. Junior members and a political commissar form part of the quorum. You're a major and a private can sit in the body that tries you. No right of appeal is created to the ordinary courts under the Act. The appeal ends with the court-martial appeal court. The unit disciplinary committees and the summary trials authorities exercise judicial power under the law as they have jurisdiction to pass custodial sentences and thus infringing on the liberty guaranteed under Article 23 of the Constitution. With the benefit of various authorities and instruments enunciating the law on the issue of independence and impartiality of courts-martial, I have examined the structure and procedure of the courts-martial in Uganda to assess how they fare in this regard. I have found as follows. A, legal qualification. Currently, the General Court-Martial, Division Court-Martial, and even the UDCs and STS as tribunals exercising judicial power have no legally qualified personnel on their quorum. Yet their jurisdiction is not limited only to disciplinary breaches, but extends to crimes or offenses that are also triable by the civil courts. This includes serious offenses that attract custodial sentence of over 6 months and the death penalty as well. These untrained persons can issue decisions on questions of law and fact. Go back to the example I gave. You take me to the theater in Monago. I will not know the difference between a kidney and the liver. Yes, that's the truth of the matter. And I'm fairly educated, as you know. Or put me as a brigade commander. Everybody will flee from the area knowing that there is no security. The decision of the judge advocate in the court-martial appeal court, who in any case is not a full member of the court, is merely advisory, as I've said, as it is not binding on the panel. The absence of legally trained personnel in the exercise of judicial power in the general court-martial and the other military courts or tribunals is at variance with the situation obtaining in the civil courts. This presents two parallel and contrasting standards in the administration of justice. The civil courts are competent as they meet the standards laid down in the Constitution, while the courts martial function in sharp converse thereto, and this is inimical to the right to a fair hearing before an independent and impartial court. Hence, it adversely discriminates against persons who appear before the courts martial. The consequence of this is that it renders the functioning of the court martials unconstitutional. B, composition of the court by military personnel. This issue gives rise to two distinct questions. First, whether a parallel system of military courts or tribunals staffed by members of the military who are aware of and sensitive to military concerns by its very nature, inconsistent with Articles 28(1) of the Constitution. Second, if the answer to the first question is in the positive, whether that is the end of the matter. However, if it is in the negative, then the next question is whether the General Court Martial, as constituted at the time the respondent was charged under the UPDF Act and regulations made thereunder, is an independent court for the purpose of Article 28(1). I find that the presence of military personnel as members of the courts martial is not by itself evidence of the court's lack of independence and impartiality. However, when viewed by an objective, reasonable person, there is a difference between active servicemen under the chain of command and former servicemen who are in retirement or about to retire and are therefore not influenced by any hope for promotions. Active servicemen are under the chain of command and may be influenced through the chain of command. Furthermore, the oath taken by the members of a military court under Rule 27 of the UPDF Rules of Procedure Regulations binds them to the High Command and Convener of the military courts. This stands in stark contrast with the judicial oath in the Oaths Act, Chapter 19. This, taken together with the non-inclusion of a legally qualified judge on the panel to rule on legal issues, denies the courts martial the independence and impartiality which would have clothed them with competence. The other judicial oath, you swear to protect the Constitution. In the military, you swear to protect the commander-in-chief, the other officers. That's the difference. That's the difference which comes out. Well, that's the law that Parliament passed anyway, yeah. C, manner of appointment of its members. There is the military personnel sitting on a tribunal that handles purely disciplinary matters and only imposes such punishment as reprimand, demotion, dismissal, compensation on the one hand, and military personnel sitting in a court which has the competence to try persons for crimes which attract such penalties such as custodial sentence or even the death sentence. I am of the opinion that there is a need to distinguish between the two in determining the issues concerning the courts martial. First, the appointment to the service disciplinary organs is normally limited to administrative matters, whereby the fact of the presiding officers being subject to the chain of command does not occasion any miscarriage of justice. Unlike with the appointment to the courts martial, handling substantive judicial matters where it could occasion injustice. The appointment of an officer on the courts martial by the President or High Command might not necessarily suffice to deprive the court of the requisite independence for the exercise of judicial power. However, this must be taken together with the provisions for other safeguards for the promotion and guarantee of the independence of the courts martial, and then determine the effect of such appointment on the independence and impartiality of the members of the court. The provisions for the appointment of personnel on courts martial must be in conformity with the provisions for appointments of judicial officers in the civil courts and ensure competent persons sit in all courts. D, term of office, that is security of tenure. This relates to the terms of appointment of the members of the court, including the judge advocate. The appointment of members of the courts martial is by the High Command and for a period of 1 year only, though eligible for reappointment. There are also waiting members who are appointed and can be called upon to sit in court as and when needed to realize quorum. See Regulation 21 and 23 of the UPDF Act Rules of Procedure Regulations. The fact that a member of the court is appointed only for a short period of time and on an ad hoc basis means that such a person may have no cushion against external influence by the one who appoints him or convenes the court. They do not have protections of security of tenure available to civil judges in Article 128 of the Constitution. I therefore reach the conclusion that the provisions of the law governing the courts martial do not guarantee their independence or impartiality. E. Convening authority and prosecuting authority. The convening authority performs an important role in the court-martial judicial process because the laws grants it the dual role of the court and that of the DPP. Under the powers conferred on it by Regulation 21, this authority, among other things, determines the charges to be preferred, appoints the prosecutor, issues a convening order, determines the time of trial, and procures attendance of the witnesses. It has been held in other jurisdictions, in criminal prosecutions, it is an imperative that the convening authority lies with court, which enjoys guarantee of institutional independence from the body prosecuting cases in court. However, with regard to the courts martial, the situation is wholly different. The military appoints the convener of the court from within its ranks, and similarly does so for the prosecutor of the court. It also appoints officers who are under its command to preside over the court, but accords them no security of tenure in the exercise of their function as members of the court. This situation does not portray or manifest an impartial and independent court. Accordingly then, its constitution and exercise of judicial function is unconstitutional, as it violates Article 28(1) and 44(c) of the Constitution. F. Existence of other guarantees against outside pressures, also known as objective impartiality. Most of the determinants of independence and impartiality of courts have been institutional. The other aspect of fair hearing is the legal procedure available to a suspect who appears before the GCM. Procedures of fair trial are to be observed by all courts and tribunals that are an integral part of the judicial system. No adherence to a fair hearing has a double-edged effect. The obvious one is the denial of an accused person the right of due process. The other may have an adverse effect on this, as some accused person may also escape punishment under the guise that they were not given fair hearing. Out of the minimum guarantees for fair hearing under Article 28, I only consider two. I find that the courts martial do not guarantee the right, adequate time and facilities for the preparation of a defense and to be tried without undue delay. And they also foreclose the right of appeal to ordinary courts. With regard to the right of appeal, there is international consensus that military laws and other legislation should never foreclose the right of appeal from decisions of military courts. A general foreclosure of the right of appeal to ordinary courts, inclusive of convictions for non-capital offenses, is by any legal standard unacceptable and is in our jurisdiction clearly unconstitutional. It has recently been held by the Court of Appeal that the right of appeal to the ordinary courts from military courts is unavailable since the UPDF Act does not provide for it. See Muamuzazepa case. The interpretation that highest appellate court does not refer to the Supreme Court limits the rights of military personnel as compared to civilians in capital cases, in a way that is not justified under Article 43 of the Constitution. Any law where there is no provision for the right of appeal to the Supreme Court for a person who, upon trial and conviction, is liable to suffer the penalty of death and is inimical to the right to a fair hearing. Hence, it contravenes Articles 22(1), 21, 28, and 44(c) of the Constitution. Having regard to what I have discussed above on this issue, in the light of the rights to a fair trial enshrined in our Constitution, I am therefore in full concurrence with the Constitutional Court in this regard, and accordingly, ground 2 of the appeal fails. Ground 3 and the cross appeal. I have already found that the provisions for the military courts do not have the requisite safeguards that would ensure fairness and impartiality in the exercise of their judicial function. I should point out that even if they pass the test for fairness and impartiality, it will still be incumbent on this court to determine whether or not it is constitutional to try civilians in the general court-martial or other military courts or tribunals. The impugned provisions of the UPDF Act provide that only persons subject to military law can be subjected to trial in a court-martial for a service offense. A service offense is defined in Section 2 of the Act thus, open quote, service offense means an offense under this Act or any other act for the time being in force committed by a person while subject to military law. Persons subject to military law are listed under the impugned Section 1191 G and H, which is now 1171 G and H of the UPDF Act as follows. G, every person not otherwise subject to military law who aids or abets the commission of a service offense. H, every person found in unlawful possession of 1. Arms, ammunition, or equipment, ordinarily being the monopoly of the defense forces, or 2. Other classified stores as prescribed. Both paragraphs G and H of Section 119, now 1171 of the Act are wide enough to encompass civilians within its purview, read together with Sections 2, now 1, and 179, now 177 of the Act. A key ingredient for the sustenance of the charge against a suspect as an accomplice is the naming in the charge sheet of a principal alleged to have committed the offense, which the person charged together with the principal allegedly aided or abetted. This is clearly what the ordinary meaning of the words used in the provision mean. I would accordingly agree with the majority decision of the Constitutional Court that in failing to name in the charge sheet the principal to whom the respondent was allegedly an accomplice, rendered is being charged before the court-martial under the provision of the then Section 1191H of the UPDF Act unlawful for being defective. However, should it be determined that the military court has no jurisdiction to determine matters involving civilians at all, this finding will be of no effect. The purpose and effect test in principle of constitutional interpretation is vital in determining the constitutionality of legislation. The purpose of the military courts provided for under the Constitution and the UPDF Act is to promote and ensure discipline in the military. Courts martial or tribunals are specialized courts meant to serve the function provided for in Article 209 of the Constitution, for which they require the highest form of discipline. The current effect of trial of civilians in the military courts for criminal offenses is that they will not partake in the rights enjoyed by their civilian counterparts who appear in the civilian courts for the same offenses. This includes the right to a fair hearing discussed in the resolution of Ground 2 under Article 28(1) and as provided for in the international covenants discussed above. Worse still, such persons can face trial for offenses whose trial are within the purview of the ordinary courts, with the military courts having right to impose the death penalty, and yet the law as it stands does not avail the convict the right to appear to the Supreme Court. This limitation on their rights to appear before a civilian court is not justifiable under Article 43 of this Constitution. Military trials should be limited to cases where the state party to the covenant can demonstrate that recourse to such courts is necessary and justified by objective and serious reasons in concreto. I'll explain what in concreto is. That is, to try civilians in a military court, the state must really demonstrate and prove to the satisfaction of court that it is inevitable, it cannot be done otherwise. So, A, it must be proved that the ordinary courts are not competent to hear the case, that the civil courts or ordinary courts cannot hear that case. They lack the competence to do so. B, other alternative forms of special or high security civilian courts are inadequate for the task. Hence, recourse to military courts is unavoidable or inevitable. C, referral to military courts guarantees full respect for the rights of the accused and as prescribed by Article 28 of the Constitution. The issues I've been discussing this afternoon. The burden of proving the existence of these exceptional circumstances lies with the state. It is therefore incumbent on the appellant to demonstrate that the trial of civilians by the military courts is connected to the purpose in Article 209 and 210 of the Constitution in a way that is justifiable under Article 43 of the Constitution. From the peculiar facts of the instant case, as is discernible from the record of appeal, it is clear that there was no assessment of the individual circumstances apart from the fact that one of the accused was military personnel at the material time. The provisions for the blanket trial of civilians in the military courts, either as principled in Section 1171H or as accomplices in Section 1171G, does not satisfy the limitation requirements of Article 41 of the Constitution. They are therefore unconstitutional. Likewise, the act of the trial of civilians in the military courts under those provisions is unconstitutional. Excuse me. Ground 3 of the appeal would fail, while the cross appeal succeeds. Grounds 1 and 4, jurisdiction over subject matter. The impugned sections of the UPDF Act under grounds 1 and 4 of the appeal challenge the competence of military courts to try offenses under all enactments. Section 2, now 1, taken together with sections 179, now 177, and 119, 1G, now 177, 1G, of that act leads to the concurrent jurisdiction of the military and civilian courts in criminal matters. The question here for the consideration is the constitutionality of this provision. In the light of Articles 28 and 44 of the Constitution, which the respondent contends requires trial of criminal offenses in ordinary courts before civil judges. Having found that the courts martial should not generally try civilians, I would narrow the issue at hand thus, open quote, should military officers be tried in the courts martial for all civil offenses in addition to disciplinary offenses? Close. Does their trial in the courts martial for civil offenses contravene Articles 28.1 and 44C of the Constitution? Article 28.1 of the Constitution does not expressly bar trial of military personnel in a specialized military court, which meet the criteria discussed in ground 2. This is because judicial power can properly be given to specialized courts such as